Welcome to this month's edition of Stephen's Squibs, brought to you by the Center for Child Counseling. It's time to gather around the proverbial fire and discuss Florida family law cases and more. Please welcome your host, Eddie Stevens.
Hello and welcome to the April edition of Stephen's Squibs Family Law CLE. And of course, I have my two cohorts, CARYN Stevens and GINA SZAPUCKI. Guys, how you doing today?
Hi, happy April, everybody.
Hello, everybody.
Boy, does time fly when you're having fun. And can you believe that this is our 9th episode of doing these CLEs?
Yes. Although 2020 felt like it was 9 years, so anything's possible.
Anything is possible. And we have some cool things happening today. We're going to talk about some cases. RT White is going to join us, and we're going to finally talk about the disciplinary actions that have happened for the past 3 months. And we also have Dan Kane, who will join us. He's the CEO and president of Family Law Software, and he's going to show us some updates dealing with the stimulus and other items. But first, as always, you should have your materials, and we're going to talk about all of the family law cases that came out in February 2021. The first case is an incredible prenuptial agreement, and it's a really interesting fact pattern. Back in 2001, a commercial pilot who had a estate of about $4 million sought out a wife in Colombia through a website called The Latin Connection. He was looking for a Christian-based woman of childbearing age to marry, bring to the Florida Keys, and start a family. The wife, who was a virgin and never been married, had an equivalent of a high school education and was in her second year of medical school at Columbia. I guess you go straight from high school to medical school. She was looking for a wealthy American man to marry and to bring her to the United States. So it seemed like a match made in heaven. The husband spoke no Spanish. The wife spoke no English. They had several chaperone trips to meet each other, and in June of 2001, during an unchaperoned trip to Cartagena, Colombia, the parties had intercourse, became engaged on the same day, and in that one episode, the wife became pregnant. Husband paid for her to have an abortion in August, shortly before 2 weeks before the parties got married on August 31st. The wife's family in Colombia was unaware of her premarital sex, her pregnancy, and the abortion. The parties entered into a prenuptial agreement, but they never discussed it in advance. They never negotiated its terms. And an attorney signed off on it, a Colombia attorney, saying he understood Florida law and explained it to the fiance wife, but later admitted he doesn't even know Florida law. So it's really kind of an interesting fact pattern. And to make it even more interesting, the husband said, in order for you to immigrate to the United States, this prenuptial agreement is a required form for you to sign. So the wife sought to set it aside for duress and coercion. And the case really talks about duress and coercion being two separate things. They're not synonyms, but, duress is like when someone takes your voluntariness away. They have a gun to your head, and they really go into coercion, and they quote a couple cases, and they say it's a little broader. Coercion, unlike duress, which is a condition of mind produced by an improper external pressure, like a threat or influence, that practically destroys the free agency of a party and causes him to do an act or make a contract not of its own volition. That's a pretty high standard. Coercion is much less. While duress generally occurs by means of an actual physical force or threatened physical force to one person or a person's reputation, coercion is generally defined much more broadly to include undue influence and other lesser forms of compulsion. In either instance, duress or coercion, the act of compulsion must be sufficient to overcome the recipient's free will, sought that the recipient's actions are not of his or her own violation. Florida courts recognize duress and coercion as two separate things, and they quote two coercion cases. The first one is Berger v. Berger, and that was where one party threatened the fiance that if you don't sign this prenup, I'm going to report the substantial cash receipts you've been earning from your hair salon to the IRS. And even though he had the absolute legal right to do that, you can't do that as a threat to obtain a pecuniary gain. And so that was one example of coercion. There's another case called Paris where a wife threatened to reveal the husband's I guess the husband had a child during the marriage, and she threatened that if he didn't sign a postnuptial agreement, she would tell the minor kids about the husband's situation. That was considered coercion. So looking back to the Bates case, they noted the wife was still experiencing emotional and physical pain from having an abortion just 2 weeks before the appointment at the embassy, where she signed the agreement and they had the civil union. The husband said, of course, if you don't sign this, there's no marriage. The Bates court was very careful to say that doesn't constitute coercion because, you're allowed to give that ultimatum. That's fair game. But all of these additional acts by the husband kind of raised the level of compulsion into that realm of coercion. Husband repeatedly told the wife that it was a requirement by the United States to sign this prenuptial agreement. Contrary to what the husband told the wife, immigration to the United States is not conditioned upon the wife signing that prenuptial agreement. That, combined with the time pressure aspects, the parties' courtship, the wife's vulnerable physical and emotional condition following the abortion, constitute competent, substantial evidence that support the trial court's finding of coercion. So here, the prenup was set aside. There is a lengthy dissent. So it's these coercion cases. There's 3 of them that I know of that exist, and interesting stuff. Now we're going to move into case number 2, alimony. That is going to be the Riticamos out of the 4th DCA. I can't pronounce it, but you have it in your materials. And of course, it dealt with whether you can impute income on liquid assets. And in this case, wife was receiving a part of the husband's retirement, but she was going to immediately withdraw it and buy a house. So under those circumstances, the court found it was not appropriate to use those dollars to impute income. There's another error in the case where the court found that the husband was in a dangerous occupation and required him to provide some security for alimony. And it wasn't life insurance. It was if he passed away, he would have to, instead of the wife being the 50% beneficiary of his pension, she would get all of it. The court found that that was error because the amount of that benefit went way and above the husband's alimony obligation. So the statute allows you to use other things other than life insurance to secure alimony, but it's really important that the amount matches the obligation. Otherwise, cases like Riticamos will have you reversed. So that
I think you should call it the Rita Taco. I think that's what that looks like the best, the Rita Taco case.
Everybody loves a taco. Thank you for your contribution. I'm just going to say I have a speech impediment and I said it the best I could. So that takes us through our first 2 sections of cases. We're booking through these materials, and that takes us to appeals.
Thank you, Eddie. The only case we have in appeals for this episode is Tyson v. Tyson. It is from the first district. And in this case, the former husband appealed a final judgment of divorce, and his issues were equitable distribution. The former wife cross appealed and challenged the trial court's award of attorney's fees. With respect to the former husband's portion of equitable distribution, the appellate court was able to affirm that because that was a final order and right for appeal. The equitable distribution was a final part of that order. As for attorney's fees, the appellate court had to dismiss that cross appeal because that is a non-final order and wasn't subject to appeal, meaning the final judgment entered entitlement to fees, but they hadn't determined the amount. So until the trial court determines the amount of fees, that particular issue of the judgment hasn't been fully resolved. So it's not ready for the appellate court to fully review. And that takes us to the section of attorney's fees.
The first case under attorney's fees in your materials, number 4, which is the Shaw case out of the first district. And this was a modification case that the former husband had filed, and the former wife had filed a motion for fees. And in its order, the court just simply denied the former wife's request for fees, and it made none of the requisite findings as to need, ability to pay. There was no analysis in the final judgment. At the time of the trial, the court just made an oral ruling that everybody's responsible for their own fees. And then the written judgment sort of followed the same parameters as the oral ruling at the time of trial. But even if the court is denying fees, it still has to go through the requisite findings as to why the fees were being denied. So this case was reversed and remanded back down with instructions for the trial court to either make it more precise in the final judgment or to reevaluate the findings as to why the fees were denied in the first place. The former husband in his answer brief actually argued that the fees were denied again for the former wife because she had engaged in litigious litigation, filed frivolous motions and all of that. And the record actually reflected that there was a lot of that going on. But even if there is an allegation that the fees are not being awarded because of frivolous filings or litigiousness of a party, you still have to go through the same analysis and the same findings of facts. So that was what the Shaw case stood for. The other case under fees in this month's materials is number 5, which is CF versus SB. And this is a case out of the second district. And this was a paternity case. And at the time of the trial, the mother was pleading for fees. And keep in mind that we do have those contemporaneous statutes in both dissolution cases and in paternity. So in dissolution, 6116 controls fees, and in paternity, 742-045 controls fees. So mom had made a request for fees in this paternity case. And at the time of the trial, mom was on the stand. She testified, I can't afford to pay my attorney's fees. And at that moment, mom's attorney turned to the court and said, I would request another hearing about the fees. And then the court responded on the record, I can decide entitlement today, and then we can see, and we can do that later. And when the court made that oral pronouncement of that, I'm just going to make a finding as to entitlement today, that was where everybody sort of operated under. And so once the court said it was only considering entitlement, then the parties presented their financial positions, and that was where it ended in this tranche of the trial. But the court in its final judgment said that there was no evidence presented on the need for, on the amount of fees. And of course there wasn't, because both parties and their attorneys were operating under the concept that we were only talking about entitlement. So once the court said that, it sort of boxed out the second part of the analysis, which would be the amount of the fees. So this was again reversed and remanded back down, and the appellate court said, hey, trial court, you said it was only entitlement, and that's what the folks did. So now you can have a hearing on the amount. So those are the attorney's fees cases, and now we have a child support case that GINA is going to cover.
Thank you. The only child support case for this episode is Mantilla versus the Department of Revenue. And this is based on a final administrative support order. Here, the Department of Revenue entered an administrative support order on a father for child support obligation. The father appealed by saying that the Department of Revenue made an error by imputing income to him without having showed any substantial competent evidence to have arrived at that income number that the department used. On appeal, the Department of Revenue actually conceded this error. And when the appellate court reviewed this, they did agree that when the Department of Revenue calculated income, there was no evidence to show that this father could make this monthly amount in calculating support. So this case is just a good reminder that when we do have issues with income and we are trying to dispute a party's income, just always try and remember that we have to ascertain and have that evidence to show to the judge that this is in fact what this party can make. Otherwise, you can become subject to an appealable issue. That brings us to our next section of enforcement. There's two cases. The first case is Williams v. Samuels, and this is from the 2nd District. And this was a paternity case. And here the trial court entered an order holding the father in contempt for his failure to pay attorney's fees at the paternity case level. Here, the father appealed by saying this contempt order that was entered is essentially deficient, and the trial court was required to show findings in that order that he did have the ability to comply with the order, meaning he had the ability to pay the fees, and that he willfully failed to pay those fees. Once the appellate court reviewed the transcript, they did agree that there were no findings in this order as to his willful failure to comply and whether he did have the present ability to pay these fees. So again, this case is wonderful and a great reminder that if magistrates or judges are requesting that we draft proposed orders, you do want to make sure that those findings are in your order. Otherwise, again, it could potentially subject you to an appealable issue. That brings us to the next case in enforcement. CARYN?
Yes, number 8 in your materials under enforcement is the Harrington versus Pospisil case. And this is out of the 4th District. And I actually have an interesting involvement in this case because I represented the former wife, Ms. Pospisil, in her trial court matter. So this involved some post-dissolution enforcement issues. And at the time, there was a clause in the parties' settlement agreement that said upon a reasonable request by the former wife, the former husband was to provide the child's passport to the former wife. And apparently that's what happened. And apparently former husband did not do that when it was requested of him. And mom filed a contempt motion, and the former husband, was found to be in contempt for not providing the child's passport. What he took up on appeal is the fact that at the time the court entered the order on enforcement, the court did not have the word reasonable notice in its purge provision. The court simply said that the former husband was to comply with the former wife's prospective written request for the minor child's passport and to produce it to the former wife within 48 hours of the request. Former husband argued that the court impermissibly modified the terms of his agreement by leaving out the word reasonable request, the word reasonable, and the 4th District said, no, that's not the case. The court was simply enforcing your obligation, and the word reasonable, what removing it or including it or not including it, was not a modification of the terms, and the purge was proper. So the judgment was affirmed, and that is what the Harrington case teaches us in the 4th. We're going on to equitable distribution now.
One of my favorite subjects, CARYN. We have two cases. One is the Corrales case. It's number 9 in your materials, and that was kind of an interesting case. A husband appealed, saying the court did not award him any value of his premarital home, the marital home where the parties lived, but he had owned it prior to the marriage, and the final judgment found it all to be marital. That decision was affirmed by the DCA because even though the husband owned the residence before the marriage, During the marriage, the parties had obtained various advances from equity lines of credit secured by the marital home in order to fund the family business. The debt incurred dwarfed the estimated premarital value of the property, and the marital income was used to satisfy the repayment of the obligation. So there's no discussion, but here, because the debt taking out of the marital home and repaid with marital funds was eclipsed the value of the premarital portion, it was just, the whole thing was categorized as marital, and the court affirmed that. Case number 10 is the Schnoozle case. It's a fun one, out of the third, and it dealt with the calculation of interest, and the judge just put an interest rate on the entire amount due, but the amounts came due over periodic times, and the appellate court says you really have to figure out the interest for each period, kind of like an amortization schedule. So those are, two of the three ED cases. Karen's going to handle the last one.
So the last case in equitable distribution is the Peterson case, and this is a case out of the second district. And what happened in this case is when the court fashioned the equitable distribution schedule, it failed to reflect in the schedule the amount that the husband had dissipated from his 401k post date of filing in its equitable distribution schedule. So once the court made a finding that the husband had intentionally dissipated $14,285 post-petition from his 401k, those funds should have been assigned against him when fashioning the equitable distribution schedule. The court did not do that. Instead, the wife was sort of on the hook for eating half of the cost, even though the court had already made the intentional waste and dissipation finding. So that case was reversed and remanded back down. It was affirmed on some other issues, but what this case really was about was the equitable distribution dissipation issue. So that is the Peterson case. Then we're going to move into injunctions. We have one injunction case this month, and this is the Chiscool versus Hernandez case, and this is out of the 4th district. I probably butchered that gentleman's name, but this case involved the wife or the girlfriend filing the petition for protection against domestic violence, and in her allegations contained in the petition, it was a marriage. So in her allegation, she argued that during the marriage, the husband had shook her forcibly once, and post separation, since they had separated their households, he followed her once to a doctor's appointment, and then he had posted something on social media saying he was going forward with this divorce and made his point. And the court put a permanent injunction against the husband and made a finding that there was, the wife had reasonable fear, and that she was going to be a victim of domestic violence. And what this case and what the 4th district said is that since these folks had separated, we needed to look at not only what had gone on, during the marriage, but you also had to look at the relationship as a whole. And we needed to look at what was going on post the separation as well. So it's hard to base an injunction simply upon what might have happened once during the marriage when these parties were now living in separate households. That was not all an immediate indicative that there was going to be these continuing problems since they were no longer under the same roof. So the 4th district made an interesting finding and said the court must consider the current allegations, parties' behavior within the relationship, and then the history of the relationship as a whole. So this injunction was reversed and remanded back down to the lower court, and there really wasn't a lot of evidence. I was surprised that there was actually an injunction put in place in the first go around, but nonetheless, that is what you're dealing with. So when you have folks that are now separated or separated households or in the middle of a divorce, you need to look at the entirety of their relationship when you file a petition for protection. And now we're going to move into parenting with Eddie.
We have one parenting case. It's number 13 in the materials, Paso v. Sierra, and it dealt with a lack of a finding that this was in the best interest, this parenting plan, ultimate decision making was in the best interest of a child. It wasn't in the final judgment, but we know it doesn't have to be in the final judgment. It could be an oral pronouncement. And in the Paso case, there was no transcript. So there was no way for the appellate court to determine and really review what had happened. So because of the lack of transcript, the error was unable to be preserved, and that matter was affirmed. we have a procedural case, number 14, the Cordon case. There's two little issues in that, one little issue and one big issue. Little issue was they sought to quash service on a technicality because they didn't put the location or some date on the return of service, but they were relying on an older version of the statute that did not require those things. The more important holding in Cordon was when you have a default against a parent, in child parenting issues are at issue, you still have to let that person present evidence regarding the best interest of the child. So it's not an automatic win. You still have to have that, you still have to have evidence, and you also have to allow the defaulting party to be able to present evidence in that very specific circumstance. So that is the Cordon case. Now Karen's going to talk about a couple others.
So the next case under procedure is a Department of Revenue case. And I got to be honest, I love reading Department of Revenue cases because anything that could happen in paternity world seems to happen in these cases. But this was a DOR case on behalf of a mom against a purported father. And this case was brought up to the second district on a petition for a writ of certiorari. And what had happened in this case is that mom had said that a particular man was the father of her child, and he had signed on the birth certificate because she said, "You're the daddy." And he signed and said, "Okay, I am." And he was supporting this child. And then I guess at some point he stopped supporting the child. And in the interim, mom moved in with another man. And there was rumblings of mom telling people that that new man was actually the child's father and not what we thought was purported daddy. So DOR brought an action on behalf of mom for child support. And at the time, mom testified that purported dad, man on birth certificate, the respondent in the case, was not the dad, and that the other man she lived with was the dad. And what this magistrate in the child support world tried to do, and I understand valiant attempts, what he did is he ordered DNA testing of mom and child, okay, the purported dad who was the respondent to the case, and the gentleman who mom was now living with, claiming it was the father, even though the court had no personal jurisdiction over this alleged bio dad, and the court had no subject matter jurisdiction to order this third party, the alleged biological dad, to go take a DNA test. So the court just kind of overreached and overstretched its boundaries and its capabilities under the jurisdictional problems. So this case was brought up on a petition of writ because obviously a DNA test, once it's done, would create irreparable harm. So this constituted something that the second district could hear in the middle of a case. So you can't tell somebody who's not in a case to go do something, is what this case reminds us all. And that is the number 15, the DOR case. And the other procedure case that I'm going to cover is the Armand versus Amissi case. And this is number 16. This is a third district case. This involved a crazy fact pattern, like law school essay style. This was a dissolution of marriage case. Husband had filed the case in down there in the third district, and the wife counter petitioned. And then husband turned around and dismissed his petition and moved to dismiss the wife's counter petition for lack of subject matter jurisdiction. So remember, husband started the battle here in Florida, but then husband was the one that withdrew his petition and then tried to dismiss mom's. And what he claimed is that these folks were already divorced in Jamaica and had Haiti, and had a Haitian divorce decree from down there. And I'm not sure why husband didn't remember that when he filed the initial Florida action, but nonetheless, he filed, then dismissed. And he asked the court to deal with his motion to dismiss for lack of subject matter jurisdiction, saying that there already was a Haitian divorce decree, and the court refused to address it. And should have addressed it is really what this case stood for. And there's some interesting findings in here that the husband was pro se for a long period of this case through the final hearing, and allegedly had to be prohibited from sending hundreds of emails daily to the judicial email address. And he was filing motions after motions after motions, and it's kind of one of those off the rail pro se litigants. But nonetheless, if there's a pending motion to dismiss for subject matter jurisdiction, you can't just suddenly, enter a final judgment without addressing it. And that's what this court did wrong. So it was reversed and remanded. Really interesting case to read if you have the opportunity. We have one more case in procedure, which is the Bailey case, and Gina's going to cover that.
Yes. Both Karen and I actually have a little bit of knowledge on the Bailey case. We did not work on the case on the trial court level. However, both Karen and I did assist on the appeal with this case. And in this situation, you have a husband and a wife who are going through a divorce, and the husband filed a petition for dissolution of marriage. When the wife answered, she added in the husband's mother, which would be her mother-in-law, as an indispensable party, claiming that the mother-in-law has an interest in a home that the parties are trying to partition in this divorce, along with a company that the parties owned throughout the marriage. Throughout the trial court level, the mom, or the wife, I apologize, voluntarily dismissed her third party claim. So the mother-in-law was no longer a party to this proceeding. So the mother-in-law filed a motion to intervene in the trial court level, arguing that she had a substantial interest in this divorce for two reasons. The first one is the mother-in-law was claiming that she was this company, the company's creditor, that the parties were trying to split in equitable distribution. And she was also an indispensable party in this property that the parties, again, were trying to divorce, claiming that she has a constructive trust for this. Now, the trial court denied her motion to intervene entirely as for the company and the property. So the mother-in-law appealed on these two particular issues. The appellate court affirmed in part and wound up reversing in part. In the appellate court, in order to determine how an indispensable party or a third party is to intervene into a case, the court has to go through a two-step process, and they have to have a two-step analysis. So the first part would be, you have to determine what is this party's interest in this case. And then the second part would be, now that we've determined the interest, should this party be present? Should we allow this party to intervene in this divorce case? And some of the factors that a trial court would look at to determine that would be how much of an interest does this party have? Is there any contractual language? How big is this interest? Is this a 1% interest, or is this an 80% interest of whatever particular property or distribution? So the appellate court used that two-part analysis for both the company and the property. As for the company, the appellate court affirmed the trial court's ruling that the mother-in-law should not intervene on this particular issue, because what the appellate court found is the mother-in law's argument that she is a creditor is not enough, because the mother-in-law conceded that she had an interest in this company and she sold it. So by the time the mother-in-law was trying to intervene in this case as a creditor for the company, is not a direct and immediate interest in this company. Had the mother-in-law still had her interest in the company, that may be a different story. But the appellate court agreed with the trial court's ruling. As for the property, the appellate court reversed this ruling and expressed to the court that even though the wife can correctly argue that the court is only allowed to adjudicate the husband's and wife's third interest, since there's three people to this property, the trial court's ruling on that third interest of the property would still affect this interest that the mother-in-law had. So for that reason, it's a direct and immediate interest that the mother-in-law had in this case, and therefore she should be allowed to intervene in this divorce action only as it pertains to the potential property rights that may be affected upon the divorce. And that concludes our procedure for this month. That brings us to support the final two cases. That concludes. The first case is the Department of Revenue and Clemens v. McMullen. the Department of Revenue appealed a final order of support. At the lower section, the father was testifying that he was not paying his court-ordered support obligations from another paternity action. And in this case, they were trying to ascertain the child support for this new action with this new minor child. The father testified that even though he was court-ordered to pay this child support, he was not paying it. And what had happened was, even though it was acknowledged that the father wasn't paying his court-ordered child support, it was still deducted from his net income when calculating dad's child support obligation for this new action. And the department brought this appeal, basically stating that it was error to factor in dad's court-ordered obligations that he wasn't paying. And here they use the statute 6130 section 3F, which states that court-ordered child support payments actually made may be deducted from a party's net income. So that's the key word, actually made. And here the appellate court agreed that even though dad did have a court-ordered obligation, he was not actually making those payments, even if he stated, I'm going to restart and I will start paying them. The court cannot look to future prospective payments saying he will make them, nor can they calculate that in, because he did without a doubt concede he was not making those payments. And that brings us to our final case. Eddie?
Thanks, Gina. The last support case, number 19 in your materials, Paso v. Sierra. We also talked about it under parenting, but it deals with a support issue in that the court failed to address retroactive support. Now, the court certainly has the discretion to deny retroactive support, but if they do, you got to have some finding as to why, so the appellate court can determine if that was appropriate or not. And that concludes this month's discussion of case law. And now, back by popular demand, Ralph R.T. White to discuss the past 3 months of disciplinary procedures.
Yay!
And now, a discussion of the Florida Bar's disciplinary orders since our last meeting.
Ladies and gentlemen, with me today, the great, the one and only R.T. White. R.T., how are you doing this April 15th?
I'm doing great, Eddie. Thank you for having me. Glad to be back on the show.
Yes, we love to have you, and you're always welcome. This whole thing is a genesis of our creation, so we love having you back, and welcome back to our little CLE, where we're going to talk about some disciplinary proceedings. We haven't talked about them in 3 months because we wanted to save enough room to get ethics credit. And in the meantime, we've had a whole bunch of disciplinary proceedings, and in the materials they're kind of listed in order of severity. So I think by doing it that way, you see patterns jump out at you, and there's definitely a whole bunch of patterns for this 3-month period. And we're covering December 2020 through January, February 2021. And Ralph, thanks for joining us today. You are the ethics master in Florida, AAML fellow, board certified, king of family law, and also mediator supreme.
I appreciate it. Thank you for the kind comments, Eddie.
Well, speaking of crazy family law, well, this isn't a family law case. I guess the first one is like a criminal lawyer. Holy cow. Case number 1, guy's disbarred for sneaking in a jail to make some kind of movie.
Yeah, I mean, and this one made the news. I mean, this was all over. This was national news. This just wasn't, oh, something happened in Florida. But of course, Florida man does something crazy. We're not surprised. But here we have Florida lawyer does something crazy. But this made the national news. So yeah, this guy was practicing criminal law and got the bright idea that he was going to film pornographic movies inside the jailhouse. And I did a little digging on this. I looked up and read the part of the opinion from the court. and he went as far as to go get sample contracts from the porn industry to draft contracts to have these women sign, so he could film the acts taking place.
Well, very interesting, but certainly not tolerated at all. Spark was disbarred, and I guess he fought it because there was an opinion and he didn't do the revocation. So that's a interesting first case to talk about.
Well, and the bar opinion went on to say that he was not only the producer, but he was also the actor in the film.
Well, how many people can you get in that room? So I'm thinking.
Well, he was using he brought in, he didn't have like video equipment and stuff. He was using his tablet, like
selfie stick.
iPad. No, I don't think he had a selfie stick. He had an iPad, he had a tablet of some sort, and he was filming.
So the camera was stationary.
I don't know. The bar did not.
I'm just
go into that.
How do you do that? You got the.
I don't know. He had a tablet. That's what I know from the bar opinion. And the bar went on to say that he deposited $10 into the woman's account. So that was $10 for them to perform acts on him that he could film, and with the hope of selling it somewhere down the line and creating some type of porn tape.
Or, as they put it in the opinion, for his own prurient and or financial interest. So don't sneak into jail for improper purposes. I think that's the conclusion we can get from case number 1. Case number 2 dealt with someone abandoning their law practice. And I think you see a big pattern, especially in this 3-month period, of attorneys not participating in the grievance proceedings. They are not responding to orders to show cause, and that is going to enhance the penalty, because if you're not there and not participating in the process is a rule of professional behavior. So we're going to see a couple of these folks who have somewhat minor infractions that would probably be a 1-year suspension, or maybe more, maybe less, but they got disbarred just for not participating in the process. And case number 2 is an example of that.
Yeah, what I thought odd about this case, Eddie, is that it only mentions this single client. It's so this woman who's named in the case, abandons her law practice, and it just talks about this one client. It seemed like this might have been her only client. So she had a client. She was supposed to represent this person in a state proceeding, and just takes off to Pennsylvania, closes down the law practice, and doesn't tell the client, and doesn't withdraw from the case. And it doesn't mention that there were other clients left holding the bag. So
we also don't know the disciplinary history of the attorney either. That may have been a factor in the punishment. But I think it's clear, if you don't participate, you're going to probably get disbarred. You'll see that a couple more times here. Case number 3, dealing with someone. This guy just freaked out during his own litigation and disparaged the judge, opposing counsel, other litigants and parties. And again, he failed to respond to the bar's complaint. So what you would have is normally unruly behavior, which in itself is not disbarment worthy. But case number 3, the guy got disbarred for failing to appear to the sanction hearing and to participate.
Well, I went and dug in on this one a little bit too, Eddie. I mean, he called the judges, said they were satanic monkey judges. So that weighs into it. He also implied that the Sumner County judges were addicted to narcotics and utilized witchcraft. So I think there was a little bit more going on with this gentleman than just disparaging the court, maybe some other type of mental health issues that he wasn't dealing with, and not responding to the bar and did not appear for the sanctions hearing, only led to, his demise as an attorney.
So if you get in trouble, have the wherewithal at least to participate, show remorse, and accept accountability if you did wrong. Case number 4. This was another.
Now, this is a family law case.
Yeah, this is a good reason you don't represent yourself. Actually, she had an attorney in this one, but the attorney was a party in a paternity action involving visitation, and she filed an injunction, had dad arrested, and then attempted to avoid service, stopped working, turned her phone off, and disappeared with the child. And again, she failed to participate in the proceedings. So another moment in life where you're having a manic situation, which could be mitigated if you handle the situation. But if you don't participate, I think the Florida bar is making it very, very clear, you're going to get disbarred.
Well, I think another thing, well, obviously not participating, but if you look at the underlying case, is that she was aware that this paternity action was coming. It sounds like she made up the injunction, gets him arrested, and the day the paternity action is filed, she goes and dismisses the injunction, and then she takes off. So yeah,
maybe, but you'll see some other issues like relating to alcohol, where you get much less discipline if you agree to the consequences, and of course showing remorse is all over some of these lesser suspensions, but probably worse acts. What's the next one that interests you, RT?
Well, the next one is the
number 5.
Well, number 5 is interesting. I mean, in that one, at least he gets to apply for readmission, but it was once again just not performing services for a client. Charged a fee, didn't communicate with the client, and then when answering the bar, there was at least they were nice enough to say inconsistencies regarding his services and the falsehoods of his representation. So 5 years with a chance for readmission.
So if you misrepresent something to the bar in your response, that's a really big deal. So proceed with caution. When it looks interesting next, 6 or 7?
Well, 6 is interesting in that he was previously disbarred.
Well, this guy, I think it was just like an announcement. We have to say this guy is not a lawyer. He keeps practicing law.
Yeah.
And usually there's like a permanent disbarment. I didn't see that in this opinion, but the guy just kept getting caught. Maybe the Florida bar has a unlicensed practice department that they prosecute people with. Maybe that's.
No, he kept. Yeah, it says he was disbarred and then just kept holding himself out as in good standing and the ability to practice law in Florida, which he did not have. So, and then people complained. So obviously they found out. Somebody, they obviously reported them. I don't think it was the bar that found out, because it says that the complainants in this case assert that they received legal advice and other services from off, and he did not disclose his disbarment. So
3 separate grievances. So 3 people yeah. All right, number 7. This was the attorney failed to diligently represent homeowners association, didn't communicate with the client for more than 2 years, and again, failed to respond to the Florida bar inquiries, failed to participate in the disciplinary proceedings. So normally, I don't think, one instance of failing to diligently represent a client, and you'll see examples later on where there are worse examples of behavior, but yet you don't participate, it's going to lead to that disbarment.
I don't think you give them much choice, Eddie, right? That's what they have to do. If you're not going to respond to the Florida bar, I mean, what choice are you leaving them other than to,
yank your license? Yeah, I mean, if you're not. So that's made clear in these pattern of cases. Number 9, another disbarment because he had a conflict. He owned a corporation that bought a foreclosed home and then somehow represented the person who was being foreclosed upon, and that's an obvious conflict, pretty significant, lots of misrepresentations. So disbarment. Number 9. Let's see.
I think in that one that they failed to put the clients on notice
Right.
that
And
there was the suspension.
so the way that works, depending on what level of suspension, if you don't, if you have 1 year and you don't put everybody on notice, they'll give you 2 or 3 years. If you have 3 years, then you get disbarred. So, you see these attorneys who get caught for some minor misconduct and get suspended for 30 days, and if they don't do what they're required to do, that will kind of snowball into eventual disbarment, like you have there. And then you have go ahead.
I was just going to say, case number 10, that's just unfortunately, your typical dipping into the trust account when you shouldn't be dipping into the trust account. Obviously, there were shortfalls. This person obviously knew what they were doing. It didn't seem that it was a mistake, that he received settlement funds from personal injury cases and didn't timely disperse the clients and used them, took amounts greater than he was entitled to out of the trust account. So that's going to get you in trouble.
Nothing like bouncing a trust check to trigger a bar complaint. And now we're in the disciplinary revocation, where the folks didn't go all the way through a trial. They basically gave up their law license for 5 years. They can apply 5 years after. But some of these people just didn't want to go through the process. 11, I don't think the guy had any type of a issue because he pleaded guilty to conspiracy to commit bribery, and I think that would have led to an automatic disbarment. But number 12, I don't know. He didn't diligently and properly handle matters. He didn't have client communication, and then he got into the trouble by not responding to the Florida bar inquiry. So maybe there was a shortage, but if but for the failure to respond, I don't think that's someone that loses their license. I think that should have been a suspension just for the guy's lack of participation. So, if you want to keep your ticket, you gotta deal with these issues. Our last person who is no longer an attorney, case number 13, he was basically ripping off, lying to non-attorneys relating to provisions in their, I think it was a residential property, and basically threatening some things that weren't really appropriate. Or
and a lot of times when I look at some of these, I looked at when this person was admitted to practice in 1985. So they've been practicing for a pretty long time. To when you go through the revocation process there, and you add 5 years onto somebody that's been practicing in 1985, they probably aren't coming back to practice law. It just might be just the easier thing to do. Is at least it leaves the door open, I guess, if you want to come back. But
so now we're moving into the emergency suspensions, where either you're seeing someone not participate in the process, or something of great harm is going on to the public, where the Supreme Court feels it needs to jump in and immediately stop that attorney. Case number 14 dealt with an attorney receiving 11 grand in garnished wages, and also I think there was another misappropriation of some settlement proceeds. He had not, or he failed to pay some bills out of proceeds because he hadn't responded. This emergency suspension came out. I would not be surprised in a couple months if that person is not disbarred.
Well, a lot of the emergency suspensions are just, obviously, most of them involve dealing with client funds. Dealing with client funds, we've got to straighten it out. We're just giving you an emergency suspension. Some of these are emergency suspension, and then, you need to respond to the bar inquiry, and if you don't, then further action is going to be taken.
All right. I thought 18 was interesting. That was an attorney causing great public harm by abandoning his practice, failing to appear for legal proceedings, making misrepresentations to client and a judge, and by engaging in a pattern of verbally attacking clients, former employees, and fellow attorneys. So it sounds like that attorney is just spiraling out of control. And he was only licensed in 2010. So you see a lot of really crazy behavior that, again, if you get a handle, take care of yourself, probably would not get to that point. We probably preach into the choir here, though, RT. What's the next interesting one that you saw?
Well, I don't know if there's I mean, most of the ones that we're into now seems to be just failure to do something on behalf of it. I'm going to use like the standard of care almost, a couple of these, you're not providing proper legal services to your client, not being an effective attorney. I think that's what a couple of these cases go to. Well, I mean, I guess it's more than that, because some of it they're saying is just incompetence and lack of diligence, but that's what the number 21 comes down to. Failure to properly represent someone in an immigration claim, and, failed to get the information and evidence was given to the attorney, and the attorney didn't properly provide that to the court. And then when the court asked about the evidence, that attorney wasn't forthright with the court.
We're talking about cases 20 to...
Well, I'm talking about, 20, 21.
And basically all the way through 24, because those are 3-year suspensions. And, these show you the significant bad acts. 22 is a trust account issue, making disbursements without having the clients sign off on the closing statement. 23 was an attorney that got in trouble, some criminal trouble, where she misrepresented something in an insurance claim.
25, 25, that's just, that is someone appeared in front of the court. They appeared to be under the influence of drugs or alcohol. The court requested a urinalysis. The attorney refused it. He was replaced then by in that hearing by the client's request. In another case, the attorney fell asleep during voir dire. The judge had to come in and wake him up and admonish him. And when questioned whether he was under the influence of drugs or alcohol, it was denied. And then in another matter, he was arrested on grand theft and 2 counts of petty theft. So, but he went into treatment, and upon being successfully discharged, he completed the bar's investigation, showed remorse, and provided interim rehabilitation. So in that instance, that was only an 18-month suspension.
I thought it was interesting because that was the length of his residential stay in rehab. So they just suspended him for what he said he was going to do.
So, but I mean, that's once again showing remorse, getting help for your problem. And it seems that, well, I'm happy for this person. It seems that they turned it around, which, if you would have read this without knowing that there was the rehab and remorse, you would have said, oh, this person's going to have a pretty good suspension here. But,
or if they didn't participate in the proceedings, they would be disbarred.
Sure.
So those are the big 18 months up. Now we're talking 1 year less discipline, getting into some of the smaller suspensions, and eventually the admonishments. So, 27 suspended for 6 months due to procedural deficiencies, mistakes in pleadings, and missed deadlines, not keeping people informed, just basic neglect. Again, 28, 1 year suspension for not showing up into properly noticed pretrial conferences, and the person's case got dismissed without prejudice. I think it would have been worse if it was with prejudice. Number 29, it involved the attorney actually being involved in an accident resulting in property damage and left the scene of the accident. So that's not that's not behavior, that's becoming of our profession. So he got a 1-year sentence or suspension. There was also a DUI involved in that one.
Well, I thought it was interesting that charges filed pertaining to the both accidents were dismissed, and then he was arrested on a separate incident for driving under the influence.
Different burden of proof with the disciplinary committees. So
yeah,
just because you I guess have a charge dismissed doesn't mean you're gonna not deal with the consequences of that behavior. 30. This was a weird conflict case where the attorney represented the husband and a wife in a foreclosure and then took on the divorce of one of the parties and kind of acted inappropriately. Now we're down into like the smaller suspension, 6 months. Number 31, the attorney was retained to appeal a conviction, but instead filed an insufficient Anders brief to withdraw. He was sanctioned for failing to assist the client in obtaining substitute counsel as the court ordered 3 times. So basically, he just dropped the entire case.
Well, 33 was just interesting that it was an attorney that was convicted on a misdemeanor charge of cyber stalking and sentenced to 11 months, 29 days probation without early termination. And he was required to go through and do community service, submit to mental evaluations, and he was required to undergo any recommended treatment. So I just thought that was just an interesting case, and it was I guess 91 days. That's that magic number, Eddie. Where,
keeps you from being a judge, right? The difference between 90 and 91.
Yeah, there you go. I guess that's an insider joke for the people of Palm Beach County.
Well, no, it's how the rules work. Number 34. We were talking about how he settled a personal injury case without advising his client, or some of the treating didn't pay the bills, so he got suspended for 91 days. So number 37 is kind of interesting because it dealt with an attorney drinking socially with a client, and it resulted in a physical fight between the two. The attorney was convicted of misdemeanor battery. He was intoxicated at the time of the incident, obviously, and he had a history of DUIs. So that was a 91-day suspension.
And also, it does note that he didn't provide the bar with updates regarding his ongoing criminal case, which is also a problem. If you have an ongoing criminal case, you need to make sure that you keep the Florida bar in the loop as to what's going on in that case.
Good point. Thank you for that practice tip, RT. 38, there was a 90-day suspension because the attorney had close to an $18,000 shortfall. He showed remorse. He showed acceptance of responsibility. He made immediate efforts to rectify the situation, and remedial record keeping measures instituted immediately. And he had an unblemished disciplinary record. So this is like a close call. This is where the attorney, admits, oops, and does everything right to avoid a much stiffer penalty. And 90 days sounds pretty appropriate for those circumstances.
And in that particular case, he was both licensed in New York and Florida, and there's a reciprocal action in the Supreme Court of New York as well.
I wonder if the penalty will be the same. Maybe we should check on that and report back. Number 40, attorney got in trouble for improperly requesting as a part of a settlement that the client withdraw his bar complaints. You can't do that. You can't negotiate a bar complaint away with a settlement. Number 42 dealt with attorney not withdrawing in time in a criminal case. Attorney asked him, or client asked him to withdraw for over 2 years, and the attorney ended up with a 90-day suspension. Now we are in the 60-day suspensions. 43, an attorney was suspended for 60 days because he was involved or hired for an adoption, and he did not respond to the petition for the adoption served on his client. He failed to competently and diligently handle his client's legal matter, resulting in a motion for default being entered in his against his client. So, you know, some of these are much less punishments than some conduct that might be similar, you know, nature that some folks were disbarred on, but because they did not participate, bam, disbarment. 45 dealt with a attorney who only a criminal law attorney who only visited his client once in 10 months and basically didn't provide diligent or competent representation. 46, I think an attorney got caught filing a notice of an appeal that he wasn't going to draft, but he could not find anyone else to do it, and got 2 extensions of time. And finally, they dismissed the case for lack of prosecution, and the attorney disappeared and did nothing on the case. So, you know, if you file a notice of appeal, you got to kind of be careful and watch that because you're responsible. If you're doing it just to protect the timeline and protect your client's clock, be very careful because you're on the hook. You're saying I'm responsible for this case. I thought the last case in the batch 54 was interesting because
it's his house.
You don't represent who represents himself, but this guy is trying to block a foreclosure, and he keeps filing bankruptcies, and they keep getting dismissed, and the bankruptcy court is getting real mad because God forbid you do a technical error in federal court there, and it was just full of technical deficiencies. And basically, the court concluded that his unsuccessful efforts to get that bankruptcy delayed the foreclosure action, and he was publicly reprimanded for that.
But it was on his own home. He wasn't doing this on behalf of a client. He was doing it on behalf of himself.
You know what they say
which
about,
I thought was interesting.
They say about someone who represents themselves. So,
as a fool for a client.
Yes, RT, that was a lovely discussion. Thank you for your good humor and your insight. Do you have any tips for our viewers, since it's been a while since we've heard from you? Any ethical hotspots that are going on that we should know about?
Not that I did check in on, the Florida Bar ethics website. I didn't really see anything new coming down or any proposed rules that looked exciting. So I don't really have anything to add from the ethical front, Eddie.
So we have some smooth sailing, and we can settle in that the rules that we have are becoming well settled, and we can rely on them. RT,
as far as I can tell, Eddie.
For the moment, RT, thank you. In this pandemic world, it's great to see you, and you are always welcome to join us. And thank you for the ethics credit.
Well, good to see you, Eddie, and can't wait till we can be in the same room and as they say, do it live again.
We're doing it live. RT, right. I miss you, buddy.
Miss you too, Eddie.
We are now going to have Daniel CAINE from Family Law Software come and give us updates about new law, stimulus, and other child support calculation issues. As everyone probably knows, the government recently passed a large stimulus bill, which is officially known as the American Rescue Plan. What people may not know is that it included tax provisions that can have pretty significant impacts on strategies we should be using for child support expenses, and other aspects of settlements between parties. I have with me today Dan CAINE, who's the president of Family Law Software, a software program that now incorporates all of these changes to discuss them. Dan did his undergraduate at Yale and also graduated from Harvard Law School and Harvard Business School. He went on to write an income tax software program that is now used by H&R Block. And after that, he co-founded Family Law Software, which does tax and financial planning for divorce situations. It also generates Florida child support guidelines and the financial affidavit. Dan and his team have been studying these changes closely and have been putting them in the software, which is now fully updated. And Dan is with us to discuss these changes. Dan, how are you doing today?
I'm doing great, Eddie. Thank you very much. How about yourself?
I'm glad you could join us. And I understand you have some strategy recommendations for family law practitioners based on these changes in the law.
I do, Eddie. I have 4 moves attorneys might want to make. Maybe what I'll do now is just give the headlines, and then we can go and discuss them in more detail. First, family law practitioners might consider negotiating a different support amount for 2021 than for future years. And that's because, as we'll discuss a little bit later, the Act makes child support a very different animal in 2021 than in 2020 or 2022. So that's first, different child support in 2021. Second, if there are children under age 18, practitioners should put special focus on making sure that their client claims the tax exemption for the children in 2021. And that means that if, as often happens, exemptions are alternating, you want to make sure that your client lands in 2021. Third, at least for 2021, make sure that the majority time parent is the parent who is paying the child care expenses. If the other parent is making child care payments in 2021, switch things around so that the majority time parent is the one making the payments, and you can do that within a special alimony payment or something like that. But the key is for 2021 especially, the majority time parent, if there is child care, should be making the child care payments. And the last thing is just because, as we'll see, the American Rescue Plan tax provisions are so dramatic in 2021, you really want to look at all of the impacts that the American Rescue Plan is going to have on the parties' bottom lines, after-tax bottom lines, and adjust your negotiations accordingly. So those are the 4 headlines. It's different child support amount for 2021. Make sure your client claims the exemptions for 2021. Make sure the majority time parent is paying child care expenses in 2021, and holistically look at the impact of the American Rescue Plan on especially the 2021 bottom line.
That is a good number of strategic suggestions. How about we dive down a bit deeper into each one?
Sure. Let's go. Just taking them in the order I presented them now. I'll start with the suggestion of negotiating a different child support amount in 2021. And the reason for that is that the tax changes are so dramatic that they alone can end up making a difference in the child support number, a significant difference in the child support number. And I'll just take a moment, a little bit of an aside, to explain how that happens. Not all of your listeners may be aware of how taxes interact with child support. So, as people may know, taxes are a deduction for the purposes of calculating child support. And that means that taxes and child support actually go in kind of reverse order, reverse direction. So when taxes go up, that means that the amount of money that the person has after tax goes down, which means that that person has less responsibility for taking care of the children, and therefore gets a higher child support award. Now, when the reverse happens, when taxes go down, a party's responsibility for the children goes up, and therefore the child support award goes down. And that's what happened this year for 2021 only, especially for parties that are taking care of children taxes go down pretty dramatically, as we'll see. We'll get into a little bit later the extent. And because of that, the child support awards will typically be going down in a pretty significant way for the majority time parents.
Can you
That's
give
the
me a
net.
sense of how dramatic these changes are?
Sure. So we looked at a hypothetical scenario where there are two children. And let's say that the majority time parent earns $3,000 a month and the other parent earns $6,000 a month. And let's say there's childcare, and the childcare costs are $1,300 per month, which is, I read, a nationwide average childcare. In this scenario, in Florida, child support would be $1,823, including the stimulus payment and changes to the child tax credit, the child care credit, and the earned income credit. Without those changes, child support would be $1,980 a month. So the difference is $157 a month just from the tax changes. Now, even if you omit the stimulus payments, which are a one-time benefit, just like the other tax benefits, the difference from just the other credits is about $20 a month. So what you want to do is you want to calculate child support for 2021 using all the benefits of the new law, then calculate child support without any of the benefits of the new law, and specify that for the 2021 year, it's the number that includes the benefits, and for the 2022 and later years, it's the other number. And that way, just as a matter of fairness, the child support results will reflect what the child support statute intended them to be in each of these years.
So if you use family law software like me, how would you go about that calculation?
Sure, because we could see that these changes were going to be so significant for child support, we made this easy. At the top of the child support screen, there's a checkbox. Incorporate American Rescue Act changes. You click the box, you'll see the child support result with the changes. You clear the box, you'll see the child support result without the changes. And you can, by doing that, you can instantly see how significant the impact is of the changes in your particular case.
That sounds something worth doing, Dan. What's next? I think you mentioned focused on your client claiming the exemption for 21. Why is that important?
Yeah, so again, it comes from the 2021 only provisions of the American Rescue Plan. And I'll just mention that I've been looking at taxes for over 30 years. I have never seen a tax act that had such dramatic changes that were in effect for only 1 year. It's really unprecedented in my experience. And that's why it really pays to focus on these changes and their impacts in this year. So this year, a second thing that happened is that the child tax credit is increased in a pretty significant way, but just for 2021. So people may know the child tax credit gives $2,000 per child, per qualifying child. But for 2021 only, the credit can be as high as $3,600 per qualifying child. So that puts an additional $1,600 directly in the pocket of the person who can claim the child tax credit.
Remind me again, how does one claim the child tax credit?
So that's where things get interesting. You may recall that back in 2017, under the tax bill that was passed early in the Trump administration, the tax benefit for claiming an exemption was eliminated. So a lot of people thought, oh, it doesn't matter anymore who claims the exemption. But there was a little catch in there because the person who claims the tax exemption is still the person who is able to claim the child tax credit. So in the past, that gave that person the ability to claim up to $2,000 per child. But now the exemption, which entitles the person to claim the tax credit, entitles the person who has that right, the ability to get as much as $1,600 per child directly in the pocket of the person who claims the credit.
Dan, you mentioned something about the child tax credit being worth as much as $3,600. Can you break that down for us? Under what circumstances is it worth that much? Worth less?
Sure. So, as I mentioned, as many people know, the credit has been worth $2,000 per child. What this bill does, again for 2021 only, is increase that by $1,000. So now the credit is worth $3,000 per child. And this is one of the provisions of the bill that really aims to support people with young children. If the child is under age 6, so pre-kindergarten, an additional $600. So $1,000 extra for children 6 to 18, and another $600 or $1,600 total for children under age 6. And that money goes straight into your pocket. In prior years, only a portion of it was always what they call a refundable credit. And what a refundable credit means, it's worth mentioning, is that if you don't have enough tax to make that credit have any value for you because your tax was already zero, a lot of credits are just lost. You know, the credit only reduces the tax, but if it reduces the tax down to zero, you get no benefit. But a refundable credit, if you aren't paying any tax already, because like the earned income credit wiped out your tax bill, if it's a refundable credit, you get money from the government in the amount of the credit. And that is what is happening now with the full child tax credit. That full $1,600 per qualifying child is now a check from the government, no matter what your tax status is or tax situation is, for up to $1,600 for each qualifying child.
It's like an unexpected refund there. Do you have to be the majority time parent to claim this exemption?
So actually, you do not. And this is one of the anomalies of the tax law. And many of your listeners will know this, but the full significance is really magnified this year. The question of who claims the exemption is something that can just be purely, in a divorce context, purely negotiated between the parties. You do not have to be majority time parent in order to claim the tax exemption. You just have to negotiate it and specify it in the divorce agreement and then file a particular form with the IRS.
So if 2021, whoever is claiming the children is up for discussion, or if it's alternating, it's really important to grab that 2021 year to take advantage of the value of these tax laws.
Absolutely, absolutely. So if you're alternating, I'll just say it again, you want to go in 2021, let the other party go in 2022.
What if the other side understands and is as savvy as to these changes and is aware of this additional benefit? How's a good way to proceed from that point?
So what you can do then is just negotiate that because there's this extra benefit in 2021 only, maybe you reduce, if that extra benefit is being received by the parent who's also receiving child support, maybe you agree 2021 only, we reduce child support just by an amount to cover half of that extra benefit. So that extra benefit gets divided among the parties, or change up the spousal support if there's spousal support. There's a way to negotiate to share that benefit equally between the parties. And if both parties are equally savvy, we can do that.
Does this child tax credit apply to high income taxpayers as well as low income taxpayers?
That's a good question. The credit does phase out for higher income taxpayers, but in such a way as that for 2021, more high income taxpayers or higher income taxpayers qualify than they did in other years. For example, for head of household, the phase out, which reduces the credit as income goes up, starts at $112,500. But the credit remains higher than the existing credit, that is the 2022 and 2020 level credit, until we get to $180,000. That's for head of household. For single, the phase out starts at 75, and for joint fathers, it starts at 150,000. And if it is all right, I'm going to share my screen with you and show you what I am talking about. So this graph shows the child tax credit with and without the American Rescue Plan. So the blue line here is what the child tax credit was. And this is our case with the 2 children under age 6. So we've got like a 1-year-old and a 3-year-old, something like that. And previously, the families were getting a $4,000 credit. And the phase out would start at $200,000. And by something like $280,000, it would be fully phased out. Income above that, you would get nothing. Now, the credit for the 2 children is $7,200. And it continues, and it does begin phasing out here. And it diminishes, but it stays above what it was before for a pretty long time, you know, all the way up until $180,000. And then it incomes above that, it phases down further as it did previously. So you can see that, and what we have, these are incomes on the bottom. I didn't mention that. And along the side, these are the credit amounts that you get. So that as the incomes go up, even at a pretty high level of income, you're still doing significantly better in the 2021 situation than you would have done in 2020, or than you will do in 2022, unless Congress extends these 2021 only provisions. And I should mention, and many people are probably aware, that a reason that these provisions were put in place only for 2021 is that they weren't budget busting to put them in only for 1 year. But the goal is to build popular support for these measures. This is the Biden administration's goal, build popular support for these measures, and maybe Congress will come back and extend these provisions. So it's worth, even though it's only 1 year, I mean, it's a dramatic year, still worth being aware of these provisions, just because you may find that they're not 2021 only at the end of the day.
And they also extended the child tax credit now, so it's not just to 17, it's to 18 this year, right?
That's right. That's one additional little plus, little bonus. So historically and continuing next year, your child who is 17 during the year, is not turned 18 by the end of the year, did not qualify for the child tax credit at all. In 2021, your child who is 17 during the year will also qualify for the child tax credit. So that's another benefit.
Now, Dan, you spoke about trying to arrange the majority time parent actually cutting the check for child care expenses. Why is that important?
So it's always important. It's always good planning to do that, but it's even more so in 2021. And the reason is that the American Rescue Plan really pumped up the volume on the child care credit, but again, only for 2021. So the credit previously maxed out at $2,100. That was the maximum credit you could get against child care expenses. For 2021, that credit can be as much as $8,000. And I think the idea was to give a model for how the federal government can really support working parents. And again, the child care credit, like the child tax credit, is fully refundable, but only for 2021. But what that means is the government will cut you a check, even if earned income credit wipes out your taxes, you have no taxes to pay, government will cut you a check for up to $8,000 in 2021 to help you cover child care expenses. And for a lot of people, the difference between refundable and non-refundable is the full $8,000, difference between $8,000 and zero. So it's a dramatic difference in the child care credit this year.
Now, what does a person have to do to qualify for the full $8,000 credit?
Good question. So first of all, the party and the children have to satisfy all the regular requirements for the child care credit. That is that the children, if they're not disabled, have to be under age 13 when the care is provided. They have to live with the party for more than half of the year. And that party has to be the party that paid the child care expenses. Those are the general ticket of admission to the child care credit, and the American Rescue Plan does not change that. But what is changed is the size of the credit. If there are 2 children and child care expenses are $16,000 or more, which is $1,333 per month, $16,000 per year, $1,333 per month, you get the $8,000 credit, which at $16,000 means the government is paying half the cost of your child care. In any event, if you have 1 child and you spend $8,000 or more, you can get a $4,000 credit. So again, half the expenditure, half of your expenditure would be covered by the credit. If you spend more than that, you do not get any additional credit. If you have more than 2 children, you do not get any additional credit. So the peak credit comes with 2 children and an expenditure at $16,000.
Does this also phase out for higher incomes?
It does, and in an interesting way. As with the child tax credit, it continues higher for longer, but at very high incomes, it completely phases out, which the existing child care credit does not. So I'm going to share my screen with you again. All right, so now we see the child care credit with and without the American Rescue Plan. And again, we have income along the bottom here. We have the child care credit amount along the side. And the blue line is the existing child care credit. And the red line is the child care credit in 2021 with the American Rescue Plan. And I'm sorry?
I was going to ask you how can you actually value the benefit of this change?
Right. So how much benefit it has to you depends on how much benefit you were getting before, because if before you were not getting, the earned income credit was wiping out your tax obligation, you were not getting, I don't think you were getting any benefit from the child care credit because it was not refundable. Now, you can get up to $8,000 of benefit. Again, this is our scenario with 2 children. And you can get up to $8,000 of benefit, whereas before it was a maximum of $1,200. And you see that it does start to phase down, but it plateaus above $3,000 until you get to $4,000 of income, and then it phases down dramatically and goes all the way to 0. So before, the credit would phase down to looks like $1,100 or $1,200, but however high your income was, you would still get that credit. Now, again, it's a little bit of an increase in equity. At a very high income, you get no child care credit. So it's an attempt to rejigger a little bit the tax equities here, but also to make sure that people, even people with significant incomes, are still getting some benefit from the child care credit.
What about cases of exactly equal parenting when there is no majority time parent?
So that's a really interesting question. If there's exactly equal parenting, one thing that most attorneys may not know is that when there is really exactly equal parenting, what the IRS does is that it says the higher income parent will be considered the majority time parent for tax purposes. So perhaps not surprisingly, this happens to have the impact often of reducing the credits that the government is on the hook to pay. Now, if the if you have exactly equal parenting, and one of the parents is paying the child care expenses, as you would expect, you may want to provide that parent who's paying the child care expenses is 183 overnights, and the other parent is 182 overnights, thus assuring that in the eyes of the IRS, the parent that is paying the child care expenses is the majority time parent. You would not want to be in a situation where you've specified exactly equal parenting. The lower income parent is the one that is paying the child care costs. The IRS comes in and says, oh, well, we're going to call the higher income parent the majority time parent, and therefore no child care credit, right? Just because you didn't quite specify exactly that 183, 182, that the parent paying the child care costs is the majority time parent. So just to make sure you got that, you really want to make sure that in a situation of, essentially equal parenting, the parent that's paying the child care costs should be specified as the majority time parent with, let's say 183 overnights, and that will make sure that the IRS doesn't come in and upset the apple cart for you.
Potentially saves the family $8,000.
Exactly. It's dramatic difference, really dramatic difference. And in Florida, that change does not affect child support at all or anything else. But it's not only the child care credit, it's the earned income credit, head of household classification. All of these things can be affected by that. And so you want to gain that out. You want to see the effect of switching majority time parent on all of these things. But in 2021, for the child care credit, dramatic difference, really important.
And how can family law software help kind of show you these differences?
So one of the things that you can do, we have what used to be called Negotiate tab. We just renamed it to the Analysis tab, just to make clearer what it is. And we have a screen called Ask What If. And it makes it pretty easy for you to set up side-by-side scenarios, change filing status, change who claims the exemptions, and see the impact on the bottom line. So that's one way to do it. Another way to do it is simply go to your child support screen, put in everything, put in the filing status, put in the exemptions, put in whether the American Rescue Act applies or not, and then go to your budget report. So those are two ways you'll get the same results, but it's pretty easy. Again, just either go to the What If on the Analysis tab, or just go to your regular child support screen, enter the things you want to change, filing status, exemptions, who pays child care expenses even, and then just go to the budget report, see the bottom line.
I think this takes us back to your fourth suggestion, which is to compare incomes in various scenarios, which is what you just described, and help your client make the best moves.
Yeah, that is really something that you really want to do, and especially in this year. And it's hard to say, well, the lower income parent should always claim the child care expenses, because these things can have cross-cutting impacts. There are things that maybe where the tax benefits favor the higher income parent, other tax benefits favor the lower income parent. And it's hard to see where it comes out in the wash. The best way to understand the impact of all of these changes is to do what I said a moment ago, simply either on the Analysis tab on the What If screen, or just on the child support tab and then flipping back and forth to the budget report, make the changes and see the impact on each party's bottom line.
Well, thinking of all that we have covered today, I think that was really valuable advice, especially how important 2021 is as an aberration year. And I hope our listeners take it to heart.
I hope so also. It is important, and it's really not hard to do.
Now, we just covered a lot of substance and threw a lot of information at our listeners. Is there anywhere that they can get this in a written form?
Yes, they can go to our website, familylawsoftware.com, click the About button at the top, and then blog. and look for the blog post on strategies under the American Rescue Act.
Well, Dan, I appreciate you joining us today for our podcast and our CLE. I appreciate your program, and my firm uses it and we rely on it. So thank you very much for the much needed update.
Thank you, Eddie, for having me.
Thank you for joining us for this month's edition of Stephen Squibs Monthly Family Law CLE. We hope to see you again next month. In the meantime, do something that matters. Visit www.eddiestevens.com for more information.